The next case is People versus Harold Walker. This is an argument on the application. You each have 15 minutes. You can do your best to reserve some time if you wish.
I will try to do that, but I'm not holding out hope. Good morning, Your Honors. May it please the Court. Adrienne Young from the State Appellate Defender Office. I'm here on behalf of Mr. Harold Lamont Walker. At table with me is co-counsel Angeles Meneses. I'm here because Mr. Walker is entitled to a new trial. The jury announced that they were deadlocked, and the instruction that was read in lieu of MJ Crim 3.12 was coercive. And it was coercive for three reasons. One is the language that was added to 3.12 by Judge Lillard. The second is the language that was left off MJ Crim 3.12. And last is just because of the context in which the instruction was given, which I think the Court of Appeals dissent fairly described as despotic. This was so coercive that a juror was likely to give up their honestly held convictions. That same toxicity overwhelmed sentencing. Not only was OV-19 misscored, Mr. Walker's due process right was violated because he was not sentenced by an impartial jurist. This court expanded the issue to include a review of what I'll call the Pennington policy, which was definitely in play here. Mr. Walker was sentenced in 2015, and in 2016, Judge Lillard said she has a policy of sentencing individuals to the top of the guidelines who go to trial, as Mr. Walker did. But the sentencing transcript speaks for itself. The majority described it as certainly inappropriate behavior. Name calling, Mr. Walker was called a clown 6 times. Taunting, Mr. Walker was encouraged to allocute despite saying 7 times, do what you're going to do, and 3 times, I'm through talking. And the hearing concluded with what the Court of Appeals majority described as inappropriate innuendo. So due process requires impartial judge at sentencing for Mr. Walker, but I'm confident that upon his new trial, he'll be granted that impartial jurist as well. I'm open to any questions the court has.
Counsel, the coerciveness of the instruction it's one of these legal questions that every single case has its own, set of facts and circumstances, so it's hard to pull out any clear rules for deciding the next case. At least it is for me when I read them all. Why in this case do you think, or what are the strongest reasons why this one should fall on one side of that, one side of the divide and not the other?
Well, to your point, Chief Justice, I think this definitely is a case-by-case analysis. I think it's pretty difficult to escape that reality, but I think for the 3 reasons I mentioned in my opening. So first, what Judge Lillard added on to 3.12. So you have language like, now you just give up, and that they're not operating with clear heads. And I think worst of all, the statement, if there's someone among you who's failing to participate, who's failing to follow the instructions, or there's someone who's refusing to participate in the process, you can send us a note and let us know that, and we can address that. She concludes by restating that exact thing. So you have those additional...
Why is that coercive? If there's someone amongst you who's not following the instructions, you got to let me know. I'm a little bit in a quandary thinking of this as a trial judge. It was an hour or an hour and a half. What if it was only 5 minutes? What are you supposed to do? You're still supposed to give the Allen charge as provided for in our standard jury instructions after 5 minutes? Is there nothing you can say short of an Allen charge that you haven't put in the process? You haven't even started the proper way of doing it. Look at the instructions. Get back in there. Give it some time. If someone's not following the instructions, you need to let me know. And by the way, just go get some lunch. Maybe you'll feel better when you come back.
And
what's
And I think that's absolutely true. I mean, we have case law where that exact thing happened. We have Hardin, and we have Rosen, I believe, is the case where the Court of Appeals dissent was adopted here, where there was language that wasn't exactly 3.12, but it was good enough to protect the individual convictions of the jurors, but also encourage participation. Here we don't have that 5-minute interaction. We have an extremely simple trial, a narrow issue, and by all accounts, a very engaged jury. They discussed for an hour and 15 minutes. They requested to see the one piece of evidence that was presented, the gun. They were shown the gun. And yet they said, we're deadlocked. They didn't say we can't agree. They didn't say we're screaming at each other. They said we're deadlocked. And rather than read 3.12 as the criminal instructions here for 3.11, as 3.12 indicates, after you read, all it says is after you've read 3.11, if they're deadlocked, read 3.12. That's what the note section says. So maybe it's different in a 5-minute situation, but by all accounts, this was thoughtful consideration by engaged jurors. And not only is it coercive because of this added language, it's coercive because of what she didn't say. So you have cases like Hardin and Rouse where they remind the jury, hey, you have honestly held convictions, and you should hold on to those. Here we didn't have that reminder. Justice Bernstein, you sound like you had a question.
I guess my question would be, what concerns me is that she started with that. And if you could address that. Like, she started with this idea that I'd like to know, I want names of people who are not participating. Is that a concern to you? Because I kind of found that to be a little concerning. Like, I don't understand why you would even insinuate, like, I want to know who isn't participating. I want their names. I want to know who these people are. I mean, what basis would she have had to even begin with that as a conversation topic with the jury?
Well, I want to be clear about one thing, Justice Bernstein. She doesn't expressly ask for names. What she says is, if there's someone, 1 or 2 or 3 among you who are refusing to follow the instructions or participate in the process, you can let us know that. The end result would, of course, be a note with an individual's name on it, but she doesn't expressly say, identify yourselves or show yourselves or name yourself. But
it seemed to emphasize that she was looking for individuals. And if I was a juror, I'd be a little, if I was a first-time juror, I'm not familiar with the process, I would probably feel a little anxious.
I agree, and I agree entirely, and that's why you really have to look at all 3 factors taken together. So if we just take the language as is, I agree with you, Justice Bernstein. That to me feels very coercive. That to me feels very uncomfortable. But you take that in the context of the way this trial was conducted. So you have a judge who put a juror who was late essentially in a lock box on lockdown in front of the jurors for the duration of trial. And when she was calling in the jurors to line up before the trial began, she called out another juror for being tardy. She said, juror number 8, Mr. Scott, the one who was tardy. Before the latest juror arrived, she said something bad might happen to this juror. So there's just really no question that we're in a tense environment now. And that's why context is a relevant factor. So Justice Zara, to your point, maybe you're not convinced by the language she added on to 3.12. But if you look at it in the complete context and you couple it with the fact that the honest conviction reminder wasn't there, that there wasn't a reminder to engage in thoughtful discussion, there wasn't the reminder in paragraph 2 without violating your own judgment. I think those 3 things taken together, what was said, what wasn't said in the context, really render this instruction coercive.
But roughly an hour and a half before, because they deliberated for an hour and 15 minutes, they heard all of that. And a copy of the jury instructions were sent into the jury room. And just reading the paper, I understand it could be an entirely different context, but just reading the words off of the paper, I'm not sure I get to the coercion. But anyhow, that takes us to what? What's after that?
Well, I think just to bring that that final point home, in every case, there's been initial instructions given. So you have Sullivan, where Hardin says, oh, they're just looking to see if it was coercive, and they found that it was. There was initial instructions given in Sullivan, too. So I'm not saying ignore the fact that upon initial deliberation, the judge gave thorough instructions that included an honest conviction reminder, sure, take that into account. But take into account everything else,
I
too.
guess you seem to think that an hour and 15 minutes is adequate deliberation for a day and a half trial.
I don't see anything
to
to
come to a
indicate
deadlock.
that the juror didn't thoughtfully consider.
Would your rule be anytime there's a note that comes out that says deadlock, you have to give the standard instruction?
No, my rule would be consider this on a case-by-case basis. The timing element that you're talking about would go to the context. Here, an hour and 15-minute consideration where they looked at the evidence, they had a narrow issue in front of them. By all indications, this was a thoughtful jury.
She could have just told them to continue deliberating, right?
I suppose it's possible she could have just said continue deliberating. I'm not sure if I would say that that's adequate, again, because we still have the same context. We still have the failure to remind jurors of their honestly held convictions. So it'd be different. It'd be better because there's no threatening language, but I still don't think that would hold water or whatever the saying is.
It sounds like you're in answer to Justice Zara saying she had to give the standard instruction the very first time they indicated that there was a deadlock or that they were stuck. I'm just not sure that's in practice what judges do. Sometimes they say, sorry, you've only been at it for an hour, so keep at it for a while. And then if they...
And by the way, go to lunch. Maybe you'll feel better when you come back from lunch.
Right. I mean, it's just not... There's a lot of other things she could have done, in my opinion, other than what she did do. But...
Exactly. There's a lot of other things she could have done from start to finish. And I think it would be a totally different analysis if this trial were conducted in a way that wasn't threatening or nerve-wracking for jurors, and she said something different, and they only deliberated for 5 minutes, and there were a whole bunch of different factors. But we're faced with the case we have, which is a really despotic atmosphere from start to finish, and then an instruction that departed because she didn't adopt the exact language and she added some of her own that, as Justice Bernstein pointed out, was coercive in and of itself.
Counsel, concerning these same instructions, clearly it was her intention to try to engage those jurors who she felt had not been engaged in the discussions. But is there anything at all in the instructions to sustain what the dissent in the Court of Appeals suggested was her encouragement of jurors to, quote, rat out dissenting jurors?
I think that goes to the two components that I've read a handful of times, which is just those who are failing to participate. When we look at a situation...
But there's a difference between a non-participating juror and a juror who simply isn't in the majority, right?
When there's no indication that somebody's not participating and there's a hung jury, I think it's a fair step to say you're implying that you want the people who haven't agreed with the majority. I don't think that that's a big leap.
So you see these terms as being tantamount to each other?
I think the Court of Appeals dissent analysis was accurate.
So the words are... Now, if there's someone among you who's failing to follow the instructions, or there's someone who's refusing to participate in the process, you can send us a note and let us know, and we can address that. But at this point, I'm not inclined to end your deliberations. At this point, because you've had a full day of testimony, you've only been at this discussing it for an hour. That's ratting out.
I think when, by all indications, there's jurors who are participating and you say who's not participating, even though everyone is.
If someone's not participating, you can send out us a note and we can address that.
I think what's most important here is that even if you disagree with that piece of the dissent analysis, Justices Markman and Zara, the plain language as it is, not asking to rat out, just saying, hey, who's not participating, tell me who it is, coupled with the failure to have the honest conviction reminder, coupled with this entire environment, what made the instruction, rendered the instruction coercive. So even if you don't buy what the dissent's selling, you don't have to. The three factors here are render the instruction coercive such that someone would give up their honestly held convictions. I'm happy to turn the page, even though I think Mr. Walker's entitled to a new trial. I'm happy to field any questions with the remainder of my time on
Can I very
OB-19.
quickly ask you about the issue that's troubling me a little bit, and that's the top of the guideline issue? She indicated, I think right after the, well, maybe you can clarify the chronology, but she indicated that she had been prepared to sentence defendants somewhere other than the top of the guidelines, somewhere in the middle of the guidelines, prior to him acting up at the sentencing. What is the significance that this court should accord that statement in trying to assess whether or not she was a judge who was locked into the proposition that if you go to trial, I'm going to sentence you to the top of the guidelines?
Well, I think Pennington addressed this very issue. When someone states on the record, as she did in 2016, following Mr. Walker, may I finish this? Following Mr. Walker's sentencing, that she has a policy of going to the top of the guidelines. I don't want to say her language is rendered meaningless because that's not a fair quotation of the Pennington court, but...
Isn't there some consequence that she didn't repeat that in this case, though?
No. I don't think there is. But even if this court doesn't buy the Pennington argument, there's a due process right to an impartial jurist, and the sentencing transcript speaks for itself. As the dissent said, the sentence was based on emotion and not reason. And so for that
But
alone...
I'm trying to understand. You say the transcript speaks for itself, and sometimes it does, sometimes it doesn't. The only two things that I'm clearly deriving from the transcript is that she said that she had been prepared at one juncture to sentence somewhere in the midst of the guidelines, and she also didn't say something that she had inappropriately, in my judgment, said in some earlier cases.
And a year later, she said, I have a policy of going to the top of the guidelines or higher for people who go to trial. Mr. Walker went to trial, and she said part of what convinced her to change her mind about being in the middle of the guidelines is his failure to admit guilt. And so that's entirely in keeping, in the exact portion you're talking about, that's entirely in keeping with the Pennington policy that she said she had in place.
Thank you, counsel.
Thank you.
And good morning, may it please the court. John Voitala, representing the Wayne County Prosecutor's Office and the people of the state of Michigan. I really don't have anything to say in my free fire zone, but I will address one of the questions that the Chief Justice did present. It is kind of based on the facts of how do you decide whether this is coercive instruction or not. And I think you need to look at what the language actually was and not speculate as to what the jurors were thinking. Because that's what we're looking at. We're looking at what the judge said and whether the judge did something to coerce these particular jurors. And I think when you have language, and there's other cases that say this, like we're going to keep you in the jury room for 4 days. You heard 4 days of testimony. You got to stay here for 4 days. Things of that nature, that is an indication that the judge is trying to say, listen, you come to a conclusion or you're going to sit in that jury room for a long time. That doesn't exist in this particular case.
What weight do we give to the earlier interactions between the judge and the jurors, the late juror in particular? How do we factor that into thinking about whether the instruction was coercive?
Well, I think you have to look at it also in the general terms of even the instructions that were given to the jury too. So you have these instances where I'm not trying to defend entirely Judge Lillard's behavior during this trial, or especially during sentencing, this particular case. But when jurors are late, it's not unlikely for a trial judge to indicate, listen, you were late, I've told you this to be on time, it's important that you stay on time, et cetera, et cetera. So I can't say that what she did earlier in the trial, then when she's instructed the jury is like, okay, when you go into the jury room, you have to keep your judgment to yourself. You have to keep your judgment, keep your wits, listen to other people. These are all things that the presumption is that the jury followed those instructions to keep the deliberations going. Not what was said earlier, not what, and in fact, there is an instruction that the court gives is don't base your verdict on anything I said or did in this particular case. I'm supposed to be a neutral tribunal in this particular case. So that said, again, you have to look at the instructions as a whole, not just in piecemeal. you have the instructions that were given prior to them starting the deliberations. Then you have this, what was not intended to be a deadlock jury instruction, but I guess can be interpreted as a deadlock jury instruction. And what words were used in those? Was there anything coercive in those particular words? I don't think so.
How would you describe this environment? How would you describe this? Just putting this all together, what kind of environment do you think this is? How would you describe it?
I would say it's a general day in the Wayne County Wayne County Court.
Really?
I mean,
for real?
Well,
is that for real? You would describe this as a normal day in the
not
Wayne?
entirely, but I do.
Especially the end soliloquy, you would describe that as is what goes
You're
on.
talking about the sentencing?
No, I'm talking about the whole thing, but then the last part of this that people can refer to in the transcript that is quite a interaction.
Yeah, well, I'm going to
day.
separate what happened at sentencing from what happened
I
in the rest
understand.
of the
I'm
trial.
trying to ask you, to explain to me,
Right.
when I look at this, because we have to look at this in a little ways. We're putting the sentencing, we're looking, they've got a number of issues here, but I'm asking you, how would you surmise this as an environment? Is it professional? Is it appropriate? I mean, what would you think?
Well, I think I agree with what the Court of Appeals majority said, and that her behavior at sentencing was troubling. It's not something that I think is becoming of a trial judge to behave in that way. But I think that is a separate question to whether what we're here for is whether the defendant was denied a fair trial and a fair sentencing. If there's any issues as far as what her behavior was at the sentencing, that's something to take up with the JTZ. And then maybe it's appropriate to make some kind of recommendation to JTC on her behavior. The question becomes whether.
But what about this issue about, again, this concern that a juror might have, based on looking at the events in a totality, and then getting that instruction. You don't think, I'm just trying to understand the perspectives here. You don't think it would be fair that a juror would possibly say, you know what, I'm just going to go with the flow on this. I've seen what's happened to some other jurors. Now, the judge is trying to ask, hey, if there's anyone who's not participating in this process, I want to know about it. And that's one of the first things that she kind of got. You don't think that's a reasonable assessment that a juror could make that, you know what, I don't want to get on her bad side. Maybe I need to just kind of keep my opinions to myself, and I better just go with the flow.
Well, again, I don't think we can speculate as to what's in the jurors' minds. We're here to determine whether the language that the court used was coercive. And so, and again, my argument is that it wasn't coercive. But, and again, I mean, your question supposes that there was this fear that the jurors had for the judge, which may or may not have occurred. We don't know that, and we're not privy to know that. We are here to look and see, did Judge Lillard say something to this jury that coerced them into reaching this jury? Did the words that she used coerce them? And it's not there, I don't think.
Let me, it's hard. We just have words on a page. We don't know how they're delivered. The delivery could make a world of difference on what constitutes coercion. If the delivery of these words are like this and stated with, some heat, that would be very coercive, I would think. But we have nothing but words. And I go through one line at a time. Well, that's not the way this works. Probably wouldn't have said that, but is that enough? And then, if there's people who aren't following the process, you can let us know. You can send another note. But then she does it again and says, and again, if there's one among you, or two, or three among you, who are refusing to follow instructions or participate in the process, you can let us know that too. With that second reiteration, are we getting to the point where there's coercion? I mean, none of this comes from the standard jury instructions, right?
Right.
And so I start to get troubled there. Help me get through that.
Okay.
That second time of saying, if there's one or two or three of you who don't participate, you can let me know too.
I mean, again, I view it as exactly as what she said, and as the Court of Appeals majority also interpreted it as, is that she's by them coming forward 90 minutes after being sent out to start the
75 minutes, I think.
75 minutes. Part of that, of course, being used up to pick a foreman, to go look at the gun, so on and so forth. So in reality, it's far less of how much time they deliberated. And now I've lost my point on that one. But in looking at that, as far as the short amount of time that they deliberated, prior to her making these comments to the jury, seemed to be an indication that this wasn't just that they actually reached they were hung. Of course, she didn't think that they were hung, because she said, if I believe that they're hung, I would give them the deadlock jury instruction. But it's an indication that she felt as though these jurors are going back there, they're not giving it their all effort, they're not trying to come to some, to follow the instructions and do what they're supposed to do in the jury room. That's how I read that particular thing, not as a coercive to come to a conclusion right now. It's more of a conclusion of the court observing that you were out for so short a period of time, you didn't even do what I told you to do, basically.
When we're thinking about the environment where the instructions were given,
Yep.
is it proper for us to consider what happened later at sentencing in relation to what that environment, what might have looked like? And let me give you a couple of examples of things that maybe we should consider, maybe we shouldn't. And I'd like to get your reaction. The judge apparently scored OV-19 on the basis that she thought the defendant and a witness who was in jail had colluded, or the defendant had somehow influenced the witness to commit perjury. It's not clear to me, but it doesn't appear that there was any evidence of that in the trial. It appears to me that that's a theory that she developed on her own. Maybe you can shed some light on that. She also said to the defendant at sentencing, "I don't believe you." She didn't say in this jury trial that the jury didn't believe you. She said, "I don't believe you," which tells me that she decided before the jury did that he was guilty, and that maybe she thought she should encourage the jury to so find. Is that something we should consider, or am I way off base thinking about things that happen later and whether they influence the judge in some way at an earlier stage?
As far as
There was a lot there. Tell me, is there
Yeah.
any evidence of collusion, or is that something she made up all on her own?
I do think that there is.
I mean, were there contacts at the jail? Were they in the same cell? Did that come into this trial? Or did she just say, well, you were in the Wayne County Jail together, and therefore he must have put you up to this?
I think by preponderance of the evidence standard at sentencing, I think you could make reasonable inferences that
Just
there
the
was some-
fact that they were in the jail together?
No,
Or
no,
was
no,
there
no,
more
no.
evidence?
No, based on the entirety of the circumstances of they both come forward with this, what I feel is a preposterous story of, I was so concerned about the fact that he was on parole that I wanted to do everything to protect him, and so that's why I hid this gun in this bush, even though he's doing everything else that's violating his parole with him. So I think the fact that, would it pass a beyond a reasonable doubt test? I don't think so. But is there a preponderance of the evidence to make this conclusion that there was some kind of
So that they were in the jail together and the story he told. Those are the two those are the two pieces of
in their
evidence?
relationship with each other? That the witness did state that the defendant was like a mentor towards him. But on that particular note, and just as that, is that I think there is, aside from the judge's conclusion as to whether this was a coercive activity, I think there is other evidence, and I put it in my brief, of why OV-19 should be scored the same as was done.
Yeah, no, and I'm not really getting to that. I just was sort of looking at the way she viewed the case later. I mean, when you, as a trial judge, when you interact, at least I would usually, after a jury trial, think of it in terms of what the jury found.
Right.
Because I wasn't asked to make those findings. And now I'm asked to sentence somebody based on the jury's finding in the case. So it would have been easy for her to say, listen, I understand you testified, the jury didn't believe you. Let's move on. That's the end of it. But it seems to me that she went further and she said, I don't believe you. And
Well, I
That's
mean,
something that I should think about when I'm trying to decide whether the jury instruction was coercive.
Yeah, and I don't, and in that regard, though, I don't think that if she had this belief that she didn't believe the defendant, and there needs to be some evidence that somehow that was communicated to the jury that, well, I don't believe him, and you shouldn't believe him either. And I don't think there is any evidence, and no evidence has been raised that was communicated to the jury. I mean, I don't think it would be uncommon for a trial judge, before the jury actually reaches a verdict, to have some idea as to how they would particularly rule in that particular case. But the question becomes, is their viewpoint, is that somehow communicated either implicitly or explicitly to the jury? I don't see any evidence that occurred here.
Do you have any comment about the issue of the issue about those who go to trial face like the high end of sentencing?
If that is in fact her policy, and I'll point out once again what was in my brief, is that there is no evidence that policy was applied in this particular case. If that is a policy, then obviously what the Court of Appeals indicated in Pennington is that is inappropriate that she have that policy, and that not be a policy that she adhered to. Again, my argument is that there is no evidence that if she had that policy at the time of this particular trial, that she actually applied that policy. As Justice Markman indicated, she had indicated that her intention was to give middle of the road prior to her engaging in name-calling with the defendant.
Thank you, counsel.
Yep,
The
thank you.
case will be submitted.